Manhattan's district attorney is asking the Supreme Court to allow a subpoena for President Trump's tax returns. In a brief filed Thursday, the DA's office argues the subpoena does not pertain to any official action, but rather a secret grand jury investigation. The statement adds these efforts were launched well before the president took office, meaning it should not be exempt from disclosing his financial records. And this comes on the same day California's Supreme Court ruled that presidential candidates do not have to release their tax returns in order to appear on the state's primary ballot. One America's Adonis Albright breaks down the ruling and what this means going into 2020.
Another turn in the ongoing battle in the courts to retrieve a copy of President Trump's tax returns. California's highest court unanimously ruled Thursday a law passed along party lines earlier this year violates the state's constitution. The move would have barred presidential candidates from being listed on the state's primary ballot if they failed to disclose 5 years' worth of their tax returns. Although President Trump isn't mentioned by name, it's clearly aimed at taking him to task. This comes amid efforts by Democrats in New York who are taking similar legal avenues to obtain a copy of the president's financial records. But earlier in the week, those efforts hit a temporary roadblock. On Monday, the U.S. Supreme Court put a hold on the Manhattan District Attorney's request for the president's records. That decision came after a lengthy battle in the Second Circuit. Federal judges ultimately ordered that accounting firm Mazars turn over those documents, and a ruling President Trump's legal team immediately brought before the Supreme Court. Although justices have not yet stated whether they plan to take up the case, their decision could set the precedent moving forward.
This bill is not clearly unconstitutional. It's not a stunt only. But on the other hand, it's not clearly constitutional. There's also probably First Amendment, freedom of association issues with voters, and perhaps privacy issues for any presidential candidate who didn't want to keep their tax returns in the public.
The ruling by California's top court comes roughly 2 weeks before oral arguments were slated to begin in the case. The measure, signed by Democrat Governor Gavin Newsom in July, was immediately challenged by the president's legal team, including the RNC and the state's Republican Party. The case was then brought before Sacramento-based district court. In his written opinion, the judge states the law violated 4 sections of the state's constitution as well as a federal law, but the state disagreed and appealed to the Ninth Circuit. However, a decision will not be reached before the deadline for California's statewide March ballot. At the time, Newsom argued the bill was a way for candidates to be more transparent and gives Golden State residents a better perspective of who their vote is going toward.
So all we're requiring is people that aspire to be president, it's not about one person, they have to disclose their tax returns, address issues of self-dealing, conflicts of interest, requiring that regardless of political party.
A portion of the law will remain intact. Gubernatorial candidates will need to disclose their tax filings in order to appear on the state's ballot. It's set to take effect in 2024. Adonis Albright, One America News.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube, and call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.